All right, thank you all for your indulgence. We'll proceed with the last case on our morning docket. Deutsche National Trust Company as trustee for et cetera versus Paul A. Green. Now 5 minutes rebuttal, okay?
Yes, Your Honor, that'd be great.
Right, go
Good
ahead,
morning. May it please the Court, Will Grimsley, on behalf of the appellant, Deutsche Bank National Trust Company, as trustee for the subject trust. I will reserve those 5 minutes for rebuttal. The underlying foreclosure case was dismissed by the trial court due to the plaintiff's allegation of a specific default date in the complaint that predated the dismissal of a prior foreclosure action that was dismissed without prejudice. In the answer brief, the appellee, Paul Green, concedes this was an error based on this court's decision in Stahlbaum. So there is no dispute that the trial court erred. However, they have asserted 4 alternative bases for affirmance pursuant to the Tipsy-Coachman doctrine. If there are no questions on the core issue, I will address each of those alternative bases. The first basis for affirmance that they assert per the Tipsy-Coachman doctrine is that the ex-wife of Mr. Green, Simi Green, was dropped from the case, was not foreclosed by the final judgment, and therefore the final judgment is void. This is an argument first raised on appeal, and the problem with the argument is it was not developed in the record, it's not supported by the record, and the trial court made no factual finding with regard to the ex-wife. In order to have the application of the Tipsy-Coachman doctrine, that particular issue must be developed in the record, and there must be a factual finding based on it. The record reflects that the ex-wife, Mrs. Simi Green, did not sign the note. She is divorced from Mr. Green. She is not living in the property. In fact, Mr. Green filed detailed property information in the record.
The idea is that the alternative basis for affirmance has to be so clear that our exercise of jurisdiction here, and if we were to remand the case, would be an exercise in futility, right?
Correct.
Because the trial judge would clearly reach the same ruling on the alternative grounds, right?
Correct. And on this first point, the record just doesn't support it. In fact, what
property appraiser records.
Yes, Your Honor.
And the record that indicates that Mr. Green is the sole owner of the property, correct?
Yes, Your Honor. So there's no evidence to support that, and even if there was evidence to support that, this court's decision in Sudoff, that's 942 Southern 2nd, 425, which we cited in our briefs, stands for the proposition that it would only be, a final judgment would only be ineffective as to Mrs. Green. It would not be void as to the other defendants who were named and were foreclosed in that case. So there is just simply no basis for application on that first point. On the second point, they assert that there was a deposition transcript of Mr. Green that was stipulated to admitting into evidence. I think that's an inaccurate description of what happened at trial. At the beginning of trial, there was the mention of a deposition transcript. The exhibit log does not reflect that it was ever admitted into evidence. It certainly was not relied upon in any substantive way by either party at trial, so it could not serve. And the underlying premise for this argument is that per Applegate, the absence of this deposition transcript precludes this court from reviewing the underlying court's factual findings, and that's just a misapplication of Applegate.
And Mr. Green testified at the trial, correct?
And he did testify at trials.
He admitted that he hadn't made the payments and...
Correct, yes, Your Honor. He admitted he hadn't made the payments. He received the default letter. He admitted that he received the default letter. He had an issue with respect to what the default letter represented, but he took no action to try to point out to anybody that there was something inaccurate in that default letter. So that, too, cannot serve as a basis for affirming the trial court's dismissal. The next two points, the next two bases that Mr. Green asked for this court to affirm, asked this court to, they're based on factual findings that the trial court did not make. Specifically, that the default letter overstated the amounts due and owing, and then secondly, that damages sought by the plaintiff were more than 5 years old. In fact, the trial court disagreed with their trial counsel, with Mr. Green's trial counsel, on those two very points. And those were not, those two issues were not cross-appealed, so they cannot be, they cannot serve as a basis for application of the Tipsy-Coachman doctrine. On the first of those 2 points, Mr. Green asserts that the default letter did not comply with paragraph 22 of the mortgage because it overstated the amounts due and owing. In support of that, he cites Bartram for the proposition that once a prior foreclosure action is dismissed, the parties are returned to their pre-complaint status, the loan is decelerated, and that he only had to make ongoing monthly payments without curing any of the arrearages. And that's just a misreading and misapplication of Bartram itself. And just the particular part of the Bartram opinion is subsection 3, where the court talks about the reinstatement provision. Now, the court does say dismissal of a prior action allows the borrower to continue to make monthly payments, but what Mr. Green is leaving out is that the reinstatement provision granted the mortgagor, even after acceleration, the continuing right to reinstate the mortgage and note by paying only the amounts past due as if no acceleration had occurred. Under the reinstatement provision of paragraph 19, the mortgagor was not obligated to pay the accelerated sums, that's the total sum due, under the note until final judgment was entered, and needed only to bring the loan current. And
That's paying the past due.
that's paying the past due arrearages and meet other such conditions as paying expenses related to the enforcement of the security interest and meeting other requirements. So
Regardless, he didn't do it.
regardless, he didn't do it. So the trial court disagreed with Mr. Green on that point. The trial court said, I believe they can get everything going back in time. Again, that was not cross-appealed. In addition, Mr. Green asked the court to find that he was prejudiced by the alleged overstatement of the amounts due and owing, and Judge Davidson did question the prejudice and ultimately concluded that he had notice, he got the notice, he saw that there was something wrong with it, but he did nothing. So there could not be a basis for affirming per the Tipsy-Coachman doctrine based on whether the default letter complied with paragraph 22. And then finally, the specific argument on damages that they assert this court should affirm on is that when the plaintiff advanced payments due to fall within the 5-year statute of limitations period, that they did not reduce the principal. They contend that the principal under the note that was due in 2009 when the first foreclosure action was filed was the same as what was alleged in the complaint in this case, and that is accurate. But that is consistent with the law, and there's a factual reason for that in this particular case. I would just cite to Justice Lawson's concurrence in the Bollettieri decision where he talked about that the foreclosure landscape has sort of misconstrued this issue or not really gotten it all completely right. What the important point is that the borrower, the homeowner, signed a promissory note whereby he agreed to repay, in this case, $180,000, and he agreed to repay that in 30 years on date certain 2036. So this loan, this note did not mature until 2036, at which time, if that day were to come, the statute of limitations on whatever was due begins to run, but we're not there yet. So now for convenience to the borrowers and to all homeowners who take out loans, those payments are, that lump sum is broken up into separate payments that they can make over that 30-year period, but the loan doesn't mature until the end of that 30-year period. Now, defaults may come and go, and perhaps the right to seek an acceleration of the loan based on an old default may not be available, but the default itself is just the vehicle, the breach that allows the plaintiff to accelerate. It has nothing to do with damages itself. So their application of the law in this case was incorrect, but factually speaking, the witness at trial explained, no, we did advance payments, and if you look at the mortgage, and I believe specifically paragraph 2, it explains how payments shall be applied, and it's A, to interest first, B, principal, and then I think C is to other amounts under Section 3 of the mortgage. Given the amount of time and the amount of accrued interest, when they advanced the loan payments, they applied each payment as to interest only, so that is why the principal was never reduced. It was applied to the interest that was outstanding first. So again, that's the fourth issue that is not factually supported by the record. Judge Davidson disagreed with him on the specific point. They did not cross-appeal that issue. So we would ask this court to reverse the dismissal with specific instructions for entry of final judgment in favor of the plaintiff. Mr. Green stipulated to standing. He stipulated that he received the default letter. Judge Davidson found that it either was in compliance or he was not prejudiced, and Judge Davidson agreed that the amounts that the plaintiff could seek all amounts going back, an issue that was not cross-appealed. So for those reasons, final judgment should be entered in favor of the plaintiff. If there are no further questions or from the bench, I will reserve.
Quite a bit of time for rebuttal. Thank you.
Yes, Your Honor.
Was this case over in Brevard County? Yes, Your Honor. Have you met your client, Mr. Green, Counselor?
Good morning, Your Honor. Latasha Scott. No, I have
Do
not
you know
met.
Mr. Green? Have you met him?
No, Your Honor. I just filed a notice of appearance last week.
Okay. Do you know where he lives? Does he live over in Melbourne? Is this house in South Brevard?
The property is located in Brevard. Yeah.
Where?
Brevard.
Yeah, I might know this. I might have, this might be a former client of mine, Paul A. Green. So I will withhold we'll withhold issuing an opinion in this case for 3 days after oral argument for you both to make inquiry as to whether you want me to recuse myself on the case. I'm sorry, Paul Green's such a common name. It just never struck me until you said that Judge Davidson handled the trial, and I can't remember the middle initial of my, yeah, but I know what it is on the pleading, but I can't remember whether the Paul Green I represented was a Paul A. Green or not. Where's the residence address? Edgewood Drive. In Melbourne. In Melbourne. Yeah. It's likely that I know him and I represented him, and you don't know. He hasn't said anything to you. You don't have any communications indications that he knows me, do you, Counsel?
Not at this time, Your Honor, but I can find out after.
I get it. You just came into the case late to cover the oral argument. So make inquiry. If it turns out that he's my former client, I want you to let counsel know, and then you need to let me know. You don't need to file a formal motion if you just, just send a letter to the clerk and tell him that you want me to recuse myself. I'll do it. Okay? Okay. All right, I'm sorry. I didn't take up any of your time with that. I just had to address that. So you have your full 20 minutes. Counsel, go ahead.
Thank you, Your Honor.
Now, in the answer brief, and I know that it was authored by Mr. Stoba, but in the answer brief, it appears to concede the issue on the statute of limitations, being that the trial court erred in dismissing the complaint based on the statute of limitations. There appears to be a concession on that issue in the answer brief.
The
by your
consent,
client?
Your Honor, the concession that is made in the answer brief is respect to the Stahlbaum opinion issued in this court on the very specific issue that is with respect to a pleading issue. It's not statute of limitations per se, insofar as 5 years within or without the filing of the
I mean,
complaint.
the
So the order,
default date in the complaint is within 5 years.
yes, Your Honor. So what we conceded, Your Honor, was that the default date in the complaint does not have to be after the order of dismissal in the 2009 case. So with respect to the remaining portion of the answer brief, we are arguing a tipsy coachman doctrine. And under the Dade County versus radio station case 731, Southern 2nd 638, the tipsy coachman doctrine means that the court can affirm the order of dismissal for any reason that's supported by the record, regardless of whether the parties have advanced or fully developed that argument. So if you look at the record and you think that there's an issue that can be affirmed on any ground, then the court can affirm the order of dismissal. And so put differently, that means that if the trial court even ruled incorrectly, the tipsy coachman doctrine requires that an appellate court will affirm the record if the result is supported by that basis. So the first basis, Your Honor, is that Simi Green did sign the mortgage. You can't have a foreclosure unless every party to the mortgage has been named in the action and foreclosed on. We have the case of Lambert that was cited in our brief.
What say you about the property appraiser's documents that are in the record that indicate that Mr. Green is the sole owner of the property?
Well, Your Honor, their complaint pled that Ms. Green is the owner of the property, and they did not amend their complaint. That's at issue in the pleadings.
They dropped her as a party, correct?
Yes, correct, Your Honor. And that was without explanation. And so in the case of Lambert, if the owner of a mortgage property or an indispensable party, and Ms. Green would be an indispensable party because she is, as I was saying, a party to the mortgage, and that's on page 303 of the records where they dropped her. But if you see the mortgage attached to the complaint, she is a party to the mortgage. So she still is an indispensable party, regardless of whether or not the property appraiser website says that she's an owner. In the case of Lambert, that is what the court held and said that an indispensable party such as Ms. Green has to be named in the lawsuit.
Was that a case where the party who was not joined challenged the judgment, or was that a case where the party that was joined challenged the judgment?
It was a case where the party was not joined. However, if she was dropped from the lawsuit, there was no opportunity for her to
No,
contest.
I didn't understand your
Yes, Your
answer.
Honor.
Was in the case that you just cited, did the non-party challenge the judgment and say, I was an indispensable party?
It was the non-party that challenged, Your Honor. In
make
this
a
case,
difference?
Ms. Green was dropped, so there was no opportunity for her to
But she could
contest.
come in, and if she was an indispensable party and she wasn't, and her interest was not foreclosed, she could challenge the judgment, right?
Absolutely, and so that's an indication that the court could affirm the order of dismissal based on the fact that she's
Why
not.
can't the court foreclose out Mr. Green? He was joined.
Yes,
Why can't his
absolutely.
interest be foreclosed?
His interest is foreclosed, but it's still void with respect to one party. But the Lambert case also says that if there's an indispensable party, the entire action should be dismissed. So that's the distinction that we're drawing here. With respect to issue 2, there is an incomplete record. Now, my opposing counsel would have the court say or think that the transcript, the depot transcript, was not a part of or a crucial part of the trial.
We have Mr. Green's testimony during the trial.
Yes, but what's also missing from the depot transcript, which should be a part of the record, is that the bank said that had Mr. Green made a payment
That's
after
not
the
in record,
dismissal,
right? So
correct.
you can argue it's not in the record, but your client could have supplemented the record with that deposition if your client believed that there was something important in that deposition.
Correct, but the Applegate, yes, Your Honor. And the Applegate case does say that the burden of putting the transcript and putting together the record is the appellant's burden. And so this,
The appellant put in the trial testimony of your client, where your client admits that he defaulted, admits that they had standing, admits that he didn't do anything to correct the issue after receiving the default notice, never
Yeah.
made a payment on the home.
And that's why Judge Davis, but Your Honor, that's a very good point, and Judge Davidson did consider that during the trial, the same questions that you presented. And she turned to the depot transcript and found on page 114 of our trial transcript, 115 of our trial transcript, 17 and 19, that the depot transcript was very important because the witness from the bank admitted that even if Mr. Green had made those payments, they would have been returned to him.
But that
So
didn't,
that-
that didn't
Yes, ma'am.
preclude you from supplementing with it. If the record's incomplete, you as the appellee can move to supplement the record, whether, and the court can rule on that motion if there's an objection. So I'm a little
I understand, Your
concerned with that
Honor.
argument that you're going to rely upon a deposition transcript, which you didn't move to supplement with, which is permitted under the appellate rules.
Your Honor, we're not relying on that at all. And yes, it is permitted under the rules. It's 9.200 subsection F. The issue that we have in this case is we're saying that you can affirm the order of dismissal because it's missing from the transcript. The judge did rely on that transcript, and she found that there was prejudice to Mr. Green because he was not informed of the correct amount to cure the default.
But he never
Then,
contacted anybody about the incorrect amount, correct?
Yes.
He never attempted to pay anybody, correct?
yes, Your Honor, you asked that.
To reinstate the loan by making any sort of payment. So even if the person at the bank had said, we wouldn't have accepted it anyway, why does that make a difference when he didn't even attempt?
So before I get to that, and I will quickly answer your question, Your Honor, and then I'll make the point that precedes the question. And yes, you've asked that before. What does it matter if he didn't make an attempt? Is there prejudice to Mr. Green? Yes, Judge Davidson thought that. She asked the same question.
What is the prejudice?
She said that the bank would have returned all of the payments. Mr. Green also...
They didn't return all the payments. That we don't know whether, they say that, but we don't know that that would have happened. It didn't happen because, and surely that perhaps would have been prejudice. If he had offered to pay, the bank says, no, I'm not taking it, then there perhaps might have been your prejudice. But when he doesn't even offer to pay, the bank's employees saying, well, we wouldn't have accepted it anyway, it doesn't make a difference.
I
because he
appreciate
never
your
offered
question.
to
Yes,
pay.
Your Honor, I appreciate your concern. The issue in this case is there's a default letter that's requesting him to pay $112,419.79
Right, which he didn't
within
respond to.
33 days.
He didn't respond to.
Yes, Your Honor. But under Bartram, the letter is incorrect in and of itself. If there is an incorrect and defective letter in and of itself, then that means there's no compliance with paragraph 22, the action required to cure the default. This court said in Samru versus Wells Fargo Bank that there's no substantial compliance with paragraph 22 where the default letter does not inform the borrower of the right to reinstate the acceleration. There's no discussion of prejudice at that point. There's no discussion of did you try to reinstate the loan? What affirmative action did you make to try to reinstate the loan? In this case, I'm saying that we should look at this particular issue and whether the bank complied with paragraph 22, its contractual obligation to correctly notify Mr. Green of the action required to cure the default. So in this case, we have the bank's witness who doesn't even know what the proper amount to cure the default is. You have uncontested testimony from the witness on page 101, we mentioned that, and you also have testimony from the witness on pages 50 to 52, where the bank's witness admits the payment history is not even enough for them to understand what amount Mr. Green is supposed to pay to cure the default. So you have a letter that does not comply with paragraph 22 whatsoever. So we argue that you don't even really get to the issue of prejudice if he tried to make the payments. The bank didn't fulfill its contractual obligation under paragraph 22.
Now, under paragraph 22, the only thing you argue is that the amount is incorrect.
Yes, Your Honor. The amount is
Anything else, what he needed to do to cure it by pay that amount, that he could assert defenses, the date that he had to cure it, all of that was in substantial compliance. The only thing that you're arguing was not in substantial compliance is the amount.
Correct, and the amount would be the action required to cure the default, which is within
They said if
paragraph
the
22.
paragraph also said if there's any sort of dispute, they contact, correct?
That's not in paragraph 22, Your Honor. So what we're arguing is that Bartram requires that after the dismissal of the case, and in fact, the bank, the first case in 2009 was dismissed on the date of May 10th, 2011, because the bank failed to amend their complaint. They just did not comply with the court's order at all. And so that case was involuntarily dismissed on May 10th, 2011. And this court has relied on Bartram in the Veldon opinion and said that as a result of the dismissal without prejudice, the prior acceleration of the debt was revoked. If the prior acceleration of the debt is revoked, that's in, Judge Lambert's concurrent opinion in Veldon. We filed the notice of supplemental authority. But so when the acceleration is revoked, the parties are put back in the place of their respective pre-acceleration positions. And that is in keeping with Bartram on page 1021 of the opinion, and I will read for the court. By the express terms of the reinstatement provision of the mortgage, if in the month after the dismissal of the foreclosure action, Bartram began to make monthly payments on the note, the bank could not have subsequently accelerated the entire note until there were future defaults. So to answer back your question, Judge Berger, Mr. Green would have paid the monthly payment that was due after the dismissal, which would have begun on June 1st, 2011. That's the regular monthly payment. No person can come up with $112,000 within 33 days, but if you apply the reasoning of Bartram, within the lender's contractual responsibility to make the correct default date and send it to the borrower, then he would have had the opportunity and made the payment. And so that is why Judge Davidson looked at the depot transcript and said, it's important to me to understand why the bank would have returned a payment if the default letter was correct.
I show that the letter informed the borrower that they would need to pay $112,419.79 within 33 calendar days to cure the default, but also stated this amount cannot be relied upon for payment and encouraged the borrowers to call customer service for the updated amount. And that the total unpaid balance of the loan was $176, but then nothing was, your client didn't contact the bank to make sure that was the correct amount.
Your Honor, the burden and the contractual
answer my
provision.
question.
Yes, I'm sorry, what was the
The client
question?
did not contact the bank to make sure that that was a correct amount.
Yes, ma'am, and that will be my standing answer to that question. And so the bank still has a contractual responsibility under paragraph 2 to correctly identify the amount. It's not the burden on the burden is not on the borrower. There's no contractual provision of paragraph 22 that says there's an additional step that you need.
So the borrower can just get can accept the acceleration letter, get it, have it served, and do absolutely nothing. Nothing. No call, no attempt to pay, nothing. And the bank loses if there's a typo in the amount.
This court's is well, Your Honor. That's putting it lightly. $15,000 to $20,000 is not a typo.
A misapplication of a decimal point or a comma in the amount, and it's a typo, and the client or the borrower does nothing to address it. Doesn't call the bank. Doesn't say, I think this might be wrong. Is this the correct amount? What is the amount I need to pay? Because I'd like to pay it. That the bank loses on that issue.
I think
with a borrower that does absolutely nothing.
Your Honor, I get where you're coming from. You're saying he got a letter, he sat on it, he did nothing. Right. Go home, sit down, right?
Bank loses, right.
But
bank
Your
loses
Honor,
if there's a typo.
But Your Honor, this court has said substantial compliance applies. It's not a typo. Substantial compliance is actually defined by the judicial system. And it says when the content of the letter is nearly equivalent to or varies in only an immaterial respect from what the mortgage requires, then the letter substantially complies. And a minor variation from the terms of paragraph 22 should not preclude the foreclosure. In this case, we're arguing prejudice because $15,000 to $20,000. a number even in the default letter that the bank could not substantiate. How is the burden on the borrower to call the bank to figure out if they've calculated
Well, to
the
establish
amount secured?
prejudice. To
Okay.
establish prejudice. How do you establish prejudice if you don't do anything?
The letter is incorrect. If the letter had been correct, Mr. Green did testify.
The letter may
Yes.
be incorrect.
And
but
Mr. Green, yes, Your
How
Honor.
do you establish prejudice, or does your client establish prejudice if your client does nothing?
Judge Davidson thought that if the client did return, it was something that could not have ever been accomplished because even if he had made the payment, the bank was going to return that payment. That's ipso facto
But we don't know
prejudice.
that that would have happened because he didn't attempt. So just answer my question about
Yes.
how your client can establish prejudice when your client does nothing.
Your Honor, the prejudice in the case is not that Mr. Green didn't do anything. The prejudice in this case is that he was not given the opportunity to make his normal monthly payment.
That he was given an opportunity.
Not the normal monthly
We
payment.
don't know because he didn't attempt. He didn't do anything. You're asking us to just assume that the bank is not going to do anything, to presume that had he...
No, Your Honor, it's not a
Let me
presumption.
finish. That if he, just presume that if he had made a payment, they wouldn't have done anything. But it's impossible for us to presume something that never occurred. He never attempted to do anything. So I don't know how an individual establishes, because it's his burden to establish prejudice, how is it that he can establish a prejudice when he sits on his hands and doesn't do anything?
Your Honor, the prejudice in this case is something that I have answered. It's under Bartram. He was not permitted to make the correct amount of his payment. The bank...
Not permitted to make a correct amount of his payment. He never attempted to make. In
But
order
if he
to
was
not
given-
be permitted
Yes,
to
Your
make,
Honor.
in order to not be permitted, you have to attempt to do something and then be told no. But there is no attempt, and so there is no. We don't even get there in this case.
I can appreciate your scenario. The issue that we're having in
That's
this
the
case
scenario we have here.
is that the letter does not substantially comply because it doesn't have the right amount for him to pay. Can you pay $114,000 if the letter is asking you to pay something that's not owed? Those amounts were never owed. With respect to Samaru, this court did not engage in a prejudicial analysis. It found that the letter was completely missing an element, which was the right to reinstate the loan. Same thing here. The letter does not ask for the correct amount due and owing. It's asking for amounts that are not owed, so it is not compliant because it is not giving the action required to cure the default. With respect to issue 4, we are arguing that in 2009, the UPB was $176,000, $448.41. The UPB from the 2009 case should never be the same in the 2015 case if the bank actually did credit back those amounts to the account. So, ipso facto, that is a preclusion of the statute of limitations if they're asking for amounts going back to 2009. So with that, we stand on our brief with that particular issue. The one thing that I do want to address in my final remaining seconds is when would the bank actually get those amounts that are owed? The default letter is asking for pre-accelerated, amounts from the prior foreclosure in 2010. Bartram specifically precludes that. And even if he didn't make an affirmative act to try to pay, the bank can still recover on that amount. It's just not supposed to be in the default letter. I've worked with lenders and mortgage loan servicers for many, many years prior to becoming defense counsel. That can be the amounts that are owed could be put back on the back of the loan in a balloon payment. Why not waive the payments up front before accelerating? The witness said in this case that they waived the payments all the way from 2010 to 2015. Well, if that happened, why not do that prior to acceleration to have a performing asset? Why not give the borrower a real, meaningful way to actually bring the loan current?
All right, Counselor, you're out of time. Thank you.
Thank you, Your Honors.
And incidentally, I didn't mean that only the bank can ask me to recuse. If your client wants me to recuse because I know him, sometimes, maybe, former clients don't want, their former lawyer as a judge. Just do it within 3 days, okay?
Yes,
All
Your
right.
Honor.
Okay, you got 8 minutes and 43 seconds left, sir.
May it please the court. Just addressing a few of the points on rebuttal here. Simi Green, the ex-wife, yes, she was named in the complaint. She was dropped from the action. One important thing that I would like to point out is that she actually filed, before she was dropped from the case, she filed a motion to dismiss improperly named party. She believed herself to be an improperly named party. The bank moved to strike that. That's what's in the record. The point there is she didn't even view herself as a properly named party. She did not sign the note, so there was no liability under this loan. She signed the mortgage as a wife of the note maker, and she didn't live in the property. There is a response or an answer filed by the unknown tenants who were occupying the property pursuant to a lease. Those were the folks that were occupying the property, not Mrs. Green. So she was not an indispensable party and properly dropped from this action. On the deposition, again, the record reflects that it was mentioned. I don't see any substantive reliance on it. Applegate is only relevant when the court makes a factual determination on a contested fact. And there was nothing that, there's no suggestion that there was something in this deposition transcript that was contested fact. The suggestion is that the bank wouldn't have taken a payment, and Judge Davidson expressed some concern about the bank not taking a payment, and I think it's important to emphasize that that's in the context of one payment. The borrower, Mr. Green, owed $112,000 to cure the arrearages, so accepting one payment, which under the mortgage terms, the bank is permitted to accept or to reject. So without fully curing the default, there was no obligation for the bank to accept a single payment. And to the default letter, we don't just have substantial compliance. This default letter strictly complied with the terms of the mortgage. It specified the default, the action to cure the default, among other things. The mortgage doesn't require that the bank explain how it arrived at a particular number. That is, Judge Berger, as you pointed out, on page 579, the default letter that was admitted into evidence, it says right there, if you have an issue, immediately call us, and on the next page, there is a number provided. Again, Mr. Green testified he did not exercise that option to call. On the Samaru is a decision of this court.
I mean, it's a condition precedent that a notice be sent, right?
It is a condition precedent, yes, Your Honor.
Which is an issue that must be raised, right?
It does have to be raised.
Right.
It's an affirmative defense that must be raised or specifically denied.
It's not really an affirmative defense, it's a specific denial under the rule, right?
It can either be a specific denial or it can be raised as an affirmative defense.
Raised here?
It was raised as an affirmative defense, not specifically pled in this context as a specific denial. There was reference to incorrect amounts stated in the default letter. But what the overarching thing that we're missing is that Judge Davidson didn't find this letter to be defective. She found that A, the bank could get the monies all the way back in time, and that B, Mr. Green took no action. So there isn't a basis to affirm.
Well, I mean, if they didn't do the right notice, it's not really, the fact that he took no action is not really relevant, is it?
It is relevant, yes, Your Honor. And I would...
If the notice was defective and he raised it as a defense, I mean, why does he have to do anything other than challenge the defective notice?
Well, this Court's, in prior decisions, beginning with Gorell, the factor that plays into that is, was there prejudice? If you have a defective default letter, was there prejudice?
That has to do with the substantial compliance issue? Whether the notice substantially complies with the mortgage? Is that what that is?
Gorell was, but in the context of this, I will just identify for the Court a recent decision of the Court for you all to take a look at. We did not raise this case. It's PNC Bank versus Roberts. Look at footnote 4 This court talks about,
Okay, don't argue it. That's good enough.
okay. And then again, to affirm on tipsy coachman, you have to have a factual determination, something developed in the record. We didn't have that here. Mr. Green cites to the Veldon case supporting the statute of limitations, and specifically to Judge Lambert's concurrence. And I too would cite to Judge Lambert's special concurrence there, because Judge Lambert there agreed with Justice Lawson's concurrence in Bollettieri that if he was writing on a clean slate, he would come out a different way. In Veldon, the court felt bound by this court's decision in Diamond that you can't get amounts due that are more than 5 years old. And one thing I really think is important to realize that is overlooked about Diamond is the bank in Diamond conceded that it could not get payments beyond 5 years. So the starting point for the court in in Diamond was only amounts in the prior 5 years. So that specific case is distinguishable from what Justice Lawson is saying. So this court is still free to consider this issue, as Justice Lawson encouraged the courts to do in his concurrence, that it's a 30-year note. It does not mature until year 30, at which time the statute of limitations begins to run on damages. And then the interpretation of Bartram that there is one sentence read in isolation that says in the month following dismissal, the borrower had the right to make payments. That's ignoring the other substantive parts of the decision of Bartram on discussing the reinstatement provision, where you have to cure the default, the arrearages, in addition to make your monthly payments going forward. And then just quickly addressing finally the unpaid balance. Again, the witness did explain at trial how the loan was applied. All those payments were applied in accordance with the mortgage to interest only first. I wanted to specifically point out that the witness did not say they waived those payments. I believe, in cross, he was asked whether they waived, and he said, no, I said that we applied those payments. There wasn't a waiver of payments. And per, I believe, paragraph 12 of the mortgage, the bank expressly has a non-waiver provision. So if there are no further questions from the bench, we would ask reversal of the involuntary dismissal with
Thank you both
instructions
for a
to...
well-argued case. We'll be in recess.